Hey, good morning and welcome to our Dean's Book Review. Today we're looking at Louise Erdrich's book, The Roundhouse. My name's Elizabeth Kronk Warner, and I have the privilege of being the Dean at the S.J. Quinney College of Law. My pronouns are she and hers. And as I like to do at the start of these events, I think it's appropriate to begin with a tribal land acknowledgement statement. I'm coming to you today, at least from the Salt Lake Valley, which was traditionally used by many Indigenous peoples in the area. And so I like to read the University of Utah's land acknowledgement statement, which says that we acknowledge that this land, which is named for the Ute tribe, is the traditional and ancestral homeland of the Shoshone, Paiute, Goshu, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many Indigenous peoples and their traditional homelands. We respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and the urban Indian communities through research, education, and community outreach activities. And that statement is particularly appropriate today, which is, of course, in November, which is Native American Heritage Month, and because we are having a discussion about tribal sovereignty and its intersection with the federal government and how that all plays out in the area of criminal justice issues. So we'll be using the book, The Roundhouse, as a launching pad for our discussion of sexual assault in Indian country. This is also a special book review for me because this is the first book review that my mom is attending. So really excited to have my mom in attendance too. So that's wonderful that all of you can join us here today. So before I turn it over to our panelists, we just thought it would be helpful to provide a brief introduction into what criminal justice and jurisdiction looks like in Indian country. And we could spend the whole hour just on that topic, and we could spend many days on that topic. But to give us a basic introduction, I want to talk about 3 statutes and 1 U.S. Supreme Court decision. So the first statute is the Major Crimes Act, which was enacted at the end of the 19th century. And what the Major Crimes Act does is it gives concurrent jurisdiction between the federal government and tribes over major crimes. So these are 14 enumerated crimes, and they're things along the lines of homicide, certainly rape would fall into that category, kidnapping, aggravated felonies, burglary, etc. And so this was a start to the federal government having a significant role in criminal justice and criminal reform in Indian country. Prior to that, and there was one statute before that, but prior to that, tribes had pretty extensive inherent sovereignty over criminal matters within Indian country. If you move ahead to the Indian Civil Rights Act, which was from the 1960s, the Indian Civil Rights Act applies many of the protections of the Bill of Rights to Indian country. But in terms of criminal justice, it does something else that is very important, which is it limits tribal jurisdiction or enforcement authority to 1 year and or a $5,000 fine for a crime. And the reason why that's important for our discussion here today is because we know that many criminals are sophisticated. And so because of that limitation, oftentimes criminals will choose to conduct their crimes within Indian country because they know that, first of all, there are jurisdictional issues because if it's not clear where a crime occurred, whether it occurred within the state territory or Indian country, it oftentimes can be difficult to determine who should prosecute that crime. And I believe Judge Waddoups is going to talk about his personal experience with that a little later today. But also criminals can say, even if the tribe were to prosecute, they're limited to 1 year and or $5,000, which when you're talking about crimes of rape, that certainly is very low enforcement authority. So the Indian Civil Rights Act, and in particular, that provision had a tremendously negative impact on the ability of tribes to effectively enforce crimes within their territory because of those limits on their enforcement authority. And then next, in 1978, we got the U.S. Supreme Court decision in United States versus Oliphant, not United States, Suquamish Indian Community versus Oliphant. And in that case, the Supreme Court held that tribes no longer have jurisdiction over non-Indians within their territory. So this was a watershed moment. The court held for the first time that tribes have been implicitly divested. So prior to the Supreme Court's holding in Oliphant, the Supreme Court had pretty consistently said that you had to have an express statement from Congress in order to have divestment. So this idea of implicit divestiture was a new idea as of 1978. But also in terms of criminal enforcement in Indian country, again, profound implications, because now for crimes committed by non-Indians, tribes no longer had authority over those individuals, which left the federal government to enforce. Now, if you think about just even the physical distance that is oftentimes between reservations and the federal government enforcement officials, such as federal marshals and federal juries, federal courthouses, you're talking hours. We see that here in Utah, where our tribes are significantly located great distances away from the federal government. So just in terms of having effective investigation into crimes, there are significant geographical and distance obstacles to effective investigations. And then when you layer over that many tribal communities have concerns with federal enforcement and belief in whether or not there's going to be effective adjudication of their claims, that's just going to further exacerbate the complications that we have in terms of effectively addressing crimes in Indian country, and in particular sexual assault, which we know, and I believe Professor Deere will probably mention this, we know already that when we're dealing with survivors of sexual assault, there are significant obstacles in general to those types of crimes. And then when you put this layer of these obstacles in Indian country, that only further complicates the matter. And then I believe Judge Waddoups is also going to talk about his perspective with this as a federal court judge and his experience. Last but not least, there have been some recent changes. So in 2013, Congress enacted the Violence Against Women's Act. And this was a small baby step towards fixing the Oliphant problem, i.e. the problem that tribes did not have enforcement over non-Indians committing crimes. Because when we're talking about sexual assault, a significant portion, if not the majority of sexual assaults in Indian country are committed by non-Indians. And so the Oliphant case had profound implications when we're talking about sexual assault. Now, under the Violence Against Women Act, Congress enacted that for intimate partner violence, and there are limits to that because you have to have an intimate relationship with the person who commits the crime against you, and not all the time are sexual assaults committed by intimate partners, but where there is an intimate partner relationship and domestic violence ensues, then the tribe may have jurisdiction in that instance, assuming that the tribe has complied with certain regulations. But even then, the tribe's enforcement authority is still limited by the provisions of the Indian Civil Rights Act, unless there's another act, the Tribal Law and Government Order, that if tribes have done that, they could potentially have increased sentencing authority. But tribe sentencing authority is still limited. So the Violence Against Women Act is definitely a step in the right direction, and Professor Deere spent a lot of time, was instrumental in the passage of that act. But there's still a long way to go, and there's still certainly challenges related to sexual assault in Indian country. So with that background, I'm going to stop talking because we have two amazing experts with us. First, we have Professor Sarah Deere, who's a distinguished professor at the University of Kansas. And she's also a MacArthur Genius and received the MacArthur Award in recognition of her substantial and important work in the area of sexual violence and domestic violence in Indian country. She is also a citizen of the Muskogee Creek tribe, and we're incredibly fortunate to have her here with us today. She's going to talk for about 15 minutes, and then after she's done talking, we're also incredibly happy and delighted to host Judge Clark Waddoups, who is a senior judge for the Federal District of the District of Utah. And as I mentioned before, he has had experience dealing with some of the jurisdictional issues around this issue of sexual assault and crime in Indian country, and has a wealth of information. And I'm I'm really pleased and we're privileged that he's taking the time to talk to us about his experiences as a federal district judge in this area. After he's done talking for about 15 minutes, I will then come back on and I will moderate our Q&A. Don't feel like you have to wait for the formal question and answer period. You'll see that there's a button at the bottom of your screen that says Q&A. Feel free to type in your question at any time. And then after our two panelists are done with their presentations, we'll get to question and answers. So Che Miigwech, and with that, I turn it over to Professor Sarah Deer. Professor Deer?
Hi, everyone. It's very nice to be here. As Dean Kronk Warner mentioned, I'm a professor at the University of Kansas. I also serve as Chief Justice for the Prairie Island Indian Community Court of Appeals, and I was former justice on the White Earth Court of Appeals back when I lived in Minnesota. So it's really nice to be here today. I've sort of dedicated my career to trying to tease out solutions to this quagmire that victims of crime in Indian country experience, which is a very dysfunctional system. It's a very bizarre system. It has contradictions, internal contradictions as far as tribal power goes. And so what that leads to is high rates of crime. When there's not enough safety net underneath the system to respond to victims in a timely way, it becomes a very difficult kind of life to live if your perpetrator is walking around. So I've taught this book many times. I've taught this novel when I was a law professor in federal Indian law and tribal law. And I teach the book now in my capacity as a liberal arts professor, particularly in law and society courses, as well as in Native feminism courses. So I use it as a textbook, and I'm not a big fiction reader, but this book reads like a law treatise to me because it's so compelling in its descriptions of this plight that we live with in Indian country. So these are pictures of a roundhouse because I realize that not everyone knows what that is. It's the title of the book. So I've got two pictures here just to give you a little bit of frame of reference. I have sort of a vintage roundhouse here on the top, and then more of a contemporary roundhouse here on the bottom. And so that's what they look like. So if you were wondering, that's what we're working with here. Now, the very sad news is that Native women experience the highest rate of violence in the United States by far, and some of the highest rates in the world for that matter. So I'm starting today with some statistics to just ground us a little bit in the reality. The most recent data that we have from the Department of Justice came from a 2016 report. So it's coming up on 5 years that it's been released. And a lot, these numbers are based on what we call victimization surveys. So it used to be, in the United States in the old days, the way that you counted crime in the United States was to count the number of police reports. Well, we know that most victims of violent crime never report their crime to the authority. So basing our crime statistics on reported cases is just insufficient. So social scientists in the late 20th century began to develop victimization surveys. And the US Census actually facilitates this process. But basically, you contact a random sample of Americans, thousands and thousands, and ask them a series of questions about their own experiences with crime, either as a victim or as a witness. And those are the numbers that then can be extrapolated with scientific integrity to the whole population. And the federal government started releasing crime in Indian country data for the first time in 1999. So it hasn't been that long that we've had these kinds of numbers, but they are replicated every year in these studies. So this is one from 2016, and I'll just show you here that this is the violence against Native women chart. And you see that over 84% of Native women will experience violence in their lifetime. So that's vast majority. And then when it comes to sexual violence, we also suffer the very highest rates of sexual violence at over 56%, right? So these numbers do include non-reported cases, okay? But most of the time when I travel to Indian country to do education programming, the communities tell me that the numbers have to be higher than that. They seem low. But it's the best estimate that we do have about the rates of violence in different communities. So you can also see here physical violence at 55, stalking at 48. So it really is, you know, the most extreme cases of violence are happening against Native women, more common than any other group. The other fascinating thing about the data is who's committing these crimes. And Dean Kronk Warner mentioned this briefly because of the Oliphant case from 1978, which ruled that tribes had lost attributes of sovereignty, including criminal authority over non-Indians. And it's a very strange case for a variety of reasons. But one of the when I teach this issue to students, what I say is, I'm currently a citizen of Kansas, right? That's where I live and work and pay taxes. But if I were to go to Missouri tonight and rob a liquor store, right, then Missouri would have jurisdiction over me. I couldn't come into court tomorrow morning and say, oh, but I'm a citizen of Kansas, so you can't prosecute me. I mean, that would be ludicrous and you know, wouldn't get anywhere. But in the situation of tribal governments, right, if I'm a non-Indian and I go onto a reservation and commit a crime, then the tribe has no jurisdiction over me. And that seems to be sort of a double standard, right? So the complaint of Oliphant and his co-defendant were that they were not citizens of the Suquamish tribe, nor did they vote in the Suquamish elections. So therefore they shouldn't be held accountable by the tribe. And again, you know, that kind of argument in another context makes very little sense. At any rate, that's the law we're working with now. And it's the law I've been fighting for 20 years to overturn, the Supreme Court case, which Congress can do. So one of the interesting things that comes out of these studies is the high rate of interracial crime committed against Native women. Now, as a starting point, we need to understand that in America, most crime is what we call intraracial. So if you're a white victim, statistically, you are likely to have had a white perpetrator, right? And that's the same for all of the other racial categories in the United States. And the only exception to that is Native people. And Native people in these victimization surveys report that they have much more experience with violence committed by non-Indians than violence committed by Indians. And in no way do I want to suggest that Native people don't hurt each other. They absolutely do. But this is the anomaly in American criminology today. So you see in this chart here, the very top two bars refer to an interracial perpetrator, right? So that means someone who is not Native, right? Someone who does not have tribal identity or tribal membership. And over 97% of Native women reported that they've had at least one perpetrator who was non-Native. And men, Native men, have reported 90% of them have experienced crime committed by a non-Indian. Now, the second set of bars refer to Native perpetrators, right? So 35% of Native women report that they have been victimized by another Native person, and 33% of men, Native men, report that they have been victimized by a Native person. And you'll notice here that these percentages add up to more than 100, right? So what this means is that Native people typically experience multiple incidents of violence during their lives. And some of that crime is committed by non-Natives, and some of that crime is committed by Natives. And so, you know, that just gives us a sense of it's not just a one-time occurrence. You know, people who are abused or are in a violent relationship, you know, they often will experience violence multiple times. The other explanation for this data is simply the sort of census statistical fact that Native women are more likely than other groups of people to be in an interracial marriage. So most Native women marry non-Natives. And so that may explain some of the discrepancy here that makes this such a unique aspect of American criminology. I can't prove to you that Oliphant caused this because we don't have data before 1978 to compare to see how many people were being victimized in 1977 before Oliphant and how many people are being victimized by non-Indians since Oliphant. We don't have that. We just don't have access to that data. So it's a little bit of conjecture, but certainly if a non-Indian is familiar with the Oliphant decision, they're often attracted to Indian country, particularly pedophiles, and a lot of drug and meth manufacturing that happens on the reservation by non-Indians. It's not that no one can prosecute them because the federal government can. It's just that it's easier to get away with things in a remote rural reservation where the tribal police have no authority over you. So that's a little about the data. Now, I just wanted to step back for just a second and talk a little bit about my tribe, the Creek Nation, which is now in Oklahoma, but we were originally in the land that is now Georgia and Alabama. And when I was in law school, I wanted to do research on how Native women were treated in my culture traditionally. And, it was just a sense of kind of self-discovery in part. But I learned that domestic violence was very rare in pre-colonial days, at least as far as the documentation is concerned. So this is an example of that. This is a man that the PowerPoint slide, I didn't get this quite right, but here on the left-hand side is William Bartram, and here on the right side is one of our early Seminole kings, or Mikos. And William Bartram was an eccentric character. He was a Quaker, and he was a naturalist, kind of a Renaissance man, and he was a good artist as well. And so he went to live in what is now Georgia and Alabama for about 10 years, and he was drawing and categorizing and labeling various different plants and animals from the southeastern United States. So he lived with and among the Creek and Cherokee people for over a decade, and in several different passages in his journals and writings and letters are these noticing that Native women are not treated disrespectfully. He said in his 10 years, he never saw or heard of an instance of an Indian beating his wife or other female, or even speaking to them disrespectfully. And so this presents a different kind of culture than the patriarchal culture that came from Europe, which is very much about women as property, right? So you see here that there's a distinction between what the Anglo-American culture would have been looking like in this time period, and then the Creek and Cherokees. And then the other thing I discovered in my research was our nation's very first rape law that was written in English in 1824. Of course, we had laws for thousands of years, but they were passed down orally. We did not have a system of writing per se. But we were an assimilated people pretty early. We intermarried with a lot of immigrants, a lot of conversions to Christianity, right? There's a lot of things that we did that were very assimilated. And one of the things that we were told as a nation is that if you want to be treated as a civilized people, you have to have a written set of laws, because that's what civilized societies do. So again, in an effort to survive, in an effort to be treated as a civilized nation, we obeyed our federal agent and we wrote down the laws in English. At that time, even in 1824, we still didn't have a written language. So these are translated into English by the clerk of the tribal council in 1824. And the interesting thing about this rape law is that there are many other laws in this set. There's 50, I think there were originally 55 laws of the Creek Nation. And most of them are very assimilated. You can almost see a copy and paste in the 19th century version of copy and paste from state laws. But this law is a little different because this certainly doesn't appear in Anglo law in 1824. You see here that the victim, the woman in this case, plays a significant role in the sentencing phase, deliberately saying, here, what she say, it be law. And that's not the system of the Anglo culture at that time. I hope that gives folks a little bit more context for the book, and some insight into why Louise Erdrich took this topic on as a critical intervention in the literature about reservation life. So I'll turn it out over to the judge.
Thank you. That was an interesting presentation and certainly consistent with everything that I've experienced as a federal judge. I practiced law for about 35 years as a civil litigator before I went on the bench. And within the first couple of years I was on the bench, I first confronted in a very serious way this complex and very difficult issue of federal and tribal court and state court jurisdiction. To talk about this as a quagmire is probably an understatement. It is an area that is in significant need of revision. One of the earliest cases I had was as an Indian that was charged with assault out in the Uinta Basin, which is part of the Uinta Ojibwe Indian Reservation. And the person was charged in state court for an assault. And his defense in the state court was that the assault did not occurred on the Indian reservation, and therefore the state court had no jurisdiction over him. Based on his motion, the charges against him were dismissed, and they immediately brought those charges in federal court. His defense in federal court was these charges did not occur on the Indian reservation, and therefore the federal court has no jurisdiction over this crime. As the case proceeded, it turns out, and this is just one of an illustrative of many complex issues relating to this subject, that part of the Indian reservation where the assault was alleged to have happened, the boundary is uncertain. It's actually been in litigation in Utah for now almost 50 years as to exactly where the boundary is between the tribal lands and the state lands. And this assault took place in an area that was uncertain as to whether it was on the reservation or not on the reservation. And it was even further complicated because some of the evidence of the assault was clothing and shoes that were scattered around in various areas. And some of the evidence was found on the reservation conceitedly, and some of the clothes were found off the reservation. And therefore it was a question as to in which location this assault actually occurred. Now, as the case proceeded, we began to dig into this issue and research and had exposure to these issues. Ultimately, the issue was resolved by the defendant pleading guilty and being sentenced. So we never ever resolved whether or not I guess he conceded that the assault was within Indian country because he pleaded guilty to the crime. But it was an early introduction to how complicated this issue is. One of the other experiences that I've had that might be of some value is one of the cases I tried, a 2-week-long trial, was a member of the tribal council who was charged with assaulting and raping his stepdaughter. The allegation was that the assault began when she was about age 11 and continued until she was 16. She was 17 at the time of the trial. Eventually, he was convicted and is serving a lengthy trial sentence. But one of the issues that kind of relates to what the discussion has been, and just demonstrates how complicated this issue is. The stepfather had been a leader in the community, and when the charges were first made against him, he was immediately released by the tribal authorities. One of the interesting things about the case that made it, I think, unique somewhat, at least in my experience, is that at age 16, when this young woman eventually went to her mother and told her mother believed her immediately moved out of the home with her then husband, and reported it to the authorities, and the FBI investigated quickly. And because of their investigation, they were able to collect DNA samples from condoms and other things that were about to be destroyed on a woodpile that annually was burned. And even I believe, without any way of proving this, that without the DNA samples, the question of whether or not she would have been believed would have been difficult, because the defense was, well, she was just a rebellious child. She didn't like being disciplined by her stepfather, and therefore she made up all these stories about the sexual abuse. Now, because of the DNA and her very credible testimony, the jury didn't accept that. But in all of these cases, the question of who to believe and who not to believe are very difficult. And I think that's even further complicated when you have an interracial challenge where you have an Indian and a non-Indian, and whether the Indian will be Native American will be believed over the non-Indian. All of these issues just complicated this whole area. Eventually, that case, as I indicated, proceeded, and he was convicted. But it was interesting to watch the reaction, because the tribe, the family supported the young woman, and she always had strong family support in court whenever she was there. But it was also very apparent that a number of people from the tribe, who were also often in the courtroom, were strongly supporting the defendant. And there was a significant split in the community as to who to believe under these circumstances, which makes all of these crimes more difficult to understand. And one of the experiences that I had prior to coming on the bench, worked as a member of the board of directors of a group called the Family Support Center. And initially, their primary purpose was to support families and women, and particularly young women, who had been sexually abused. And so I was quite aware of how wide a spread of a problem was. And my reaction, or the response that I got from people generally was, well, sexual abuse cannot be that widespread. But in that two incidences that happened in that trial that reconfirmed how difficult this issue is. One was a young man in his 20s who lived down in southern Utah next to one of the smaller Indian reservations in that area. And in order to select a jury, we had to go through the intimate questions as to whether you had any experience, whether or not families of your members had ever been accused or convicted of sexual abuse. And when I was asking this young man about his experience and whether or not he had any preconceived notions about sexual abuse on the Indian reservation, his response has always stuck with me. And he said, well, everybody in the community knows that all the girls on the Indian reservation are raped or abused by their fathers or other members of the community. And I don't think his perception about fathers is necessarily true. But the fact that it's a widespread problem and perceived to be a widespread problem on the reservation is accepted. The other experience that grew out of that trial was we had 63 people from throughout Utah, from the most southern tip of the state, from St. George clear to Logan. And we had to detail with all 63 people whether or not they had any preconceived notions or had prior biases that would affect their ability to function as a juror. And out of the 63 people, 1 out of every 3 either had themselves been abused or had a family member that had been abused or a family member who had been convicted of abuse. And that is very consistent with what the data shows, that sexual abuse is a widespread problem. Let me talk just a little more about the complexities of federal jurisdiction. I have a number of cases, some of them are continuing and still pending, as to this issue of whether jurisdiction is on the reservation or off the reservation. And the Oliphant case and the other cases that deal with this area are confusing and complex and difficult to understand. One of the unique areas of jurisdiction is that the federal court has jurisdiction to decide whether a state or a federal or a tribal court has jurisdiction. And so I have several cases in which that very issue is then brought to me, and I have to decide whether or not I send it back to tribal court or whether I send it to state court. And the case law is not clear, and it's very confusing. For instance, did the events, say it's a civil complaint, and the answer is, well, was there a contract, and where was the contract entered, and was the contract to be performed on the reservation or off the reservation? And sometimes it's both. And sometimes it's, it's very confusing as to how to sort that out. These cases also result in confusion as to who has authority. We haven't even approached the complex issue of mixed bloods. So in the Utah reservations, we have enrolled members of the tribes. We have non-members of the tribes that live on the reservation. We have non-Indians who live on the reservation, and we have mixed bloods who live on the reservation. Now, you may have thought that was just a Harry Potter phenomenon, but it's a very real thing in Native American law. And so you have the confusing circumstance. If someone's driving on a state highway through the Indian land and they get stopped, does the highway patrol officer have authority? If he is an enrolled member of the tribe, probably not. If he is a non-Indian, probably does. If he's a mixed blood, probably not. And so it just creates all kinds of problems with law enforcement. And it becomes even more complicated if you have a crime of violence or a crime of disorderly conduct or other kinds of offenses that occur within Indian country. The final thought, and then I'll be happy to entertain some questions. But as I was reading the Roundhouse book, which I thought was really well written, and if you haven't read it, I would encourage you to read the book. It's not only a strong piece of literature, which is my background, it is also a very interesting underlying legal analysis. The first thing that occurred to me as I finished reading the book was a statement that Justice Breyer made at a conference I attended some years ago. He said, one of the things that we have to recognize as judges, and he was speaking in that conference to judges, is that courts don't have armies. They don't have the ability to enforce their laws. We are dependent entirely upon people having confidence that when they come into court, they will be treated fairly, and that the decision will be based upon the facts and a fair application of the law in that court. It will not be based on a political decision or who has the most money or who has connections in the community. Now, that in some ways is aspirational because as humans, we sometimes err. But his sentence, so what his charge was to this group of judges is that you need to act in a way that the community perceives that you are acting fairly and acting with authority. And the one thing that may or may not have occurred to you as you read the Roundhouse book is what happened when there was a breakdown in the confidence in the court system. In other words, the ultimate outcome in the novel, I think, is a comment the fact that where there is a breakdown in the confidence that the judicial system, whether it's in the federal system or the state system or in the tribal court system, then people are inclined to take in their own hands justice. And I think that's one of the most meaningful comments about this book is what is justice and where can justice be heard? And it can't be heard, and if there's not confidence that it will be heard in the court, then people will seek out and do justice in their own way. The ramifications of this are very significant, not only in the criminal area, but in the civil area. Some of the cases that I've dealt with deal with whether or not businesses that are not situated on the reservation, maybe non-Indian businesses, that the tribe wants to come on the reservation and do a particular job or contract to construct a particular feature, whether or not they can have confidence that they will be treated fairly in the event that there's a dispute over the performance of the contract. And that dispute is very, very difficult because if they don't know whether or not they can go to a state court and get relief, generally, in most cases, they're not going to be able to go to a federal court. And if they don't have confidence that they will have jurisdiction in a tribal court in which they will be treated fairly, then it breaks down the whole structure of how our commercial relationships play out on the reservation. So this whole question of jurisdiction is far broader than just the criminal area, but I think that it affects all of these areas and is a very important an area that I wish Congress would address. The courts don't seem to be able to address it in a consistent way. If you delve into the question of Indian law, you find depending on which circuit you're in, depending upon which case you're reading, you have confusion as to how the law applies. And when you get down to the tribal court level, some tribal courts and tribes have quite well developed legal principles. They have written decisions. They have codes that they follow. And for, at least in my experience, they have well-educated people that are attempting to apply these rules. But then you get into another area of Indian law that relies upon tradition, and some of that is not written. And it's very confusing to know exactly how that would apply and how it applies from one generation to the next generation as they try to apply the traditions of their fathers, some of which is understood by the Indian fathers, but not well understood by others. So it's just a whole confusing area. And so all in all, I think this is an area that really needs attention. And I'm not sure how to solve the problem, except that to go back to where I started, I agree wholeheartedly. This is a quagmire and really needs to be addressed by those who are writing and thinking and trying to persuade Congress as to how to correct some of these uncertainties.
Well, that was fantastic. Thank you so much, Professor Deere and Judge Waddoups, for your tremendous insights and for kind of teasing out the issues that are discussed in the books and helping us to understand why Louise Erdrich decided to write on this topic. So we now have time. We've got about 13 minutes for questions and answers. So again, at the bottom of your screen, you should see a button that says Q&A. So feel free to submit your questions there. And to get us started, both of you mentioned that it would be helpful if Congress did something in this space to try to address this problem. In a perfect world, we obviously have a new Congress coming in, some new Congress people coming in January. What would a congressional fix look like?
Well, thank you for that. Just about a year ago today, I was on Capitol Hill lobbying actually Republican senators to support the provisions of the Violence Against Women Act that we're currently asking for. As Dean Kronk Warner mentioned, we did have a victory of sorts in 2013 when the reauthorization of VAWA was signed by Obama, and that for the first time started to chip away at Oliphant by allowing tribes to prosecute non-Indians who committed acts of domestic violence in Indian country. The next ask, it's a little frustrating that it's so incremental. I would like to see Congress simply legislate Oliphant into the oblivion, but that's not seemingly possible. So we're asking for additional jurisdiction over non-Indians for crimes of sexual assault, homicide, assault on a police officer, child abuse, and another set of those kinds of laws that tribes would have their jurisdiction returned. But what gets in the way of a lot of this challenge for tribal nations is poverty. Criminal justice system is extremely expensive endeavor, right? And most tribes have, limited resources. And one of those myths is that Indians are all rich because of casinos. And there are a handful of wealthy tribes, but by and large, Native people live in very high poverty communities. And so tribal justice systems struggle to offer the basics, a bailiff, a metal detector, a courtroom. I clerked for one tribal court in law school, and the courtroom was behind the broom closet behind the gas station. And so, you're just trying to constantly figure out how to fund basic criminal justice. And a lot of tribes don't exercise any criminal justice authority because of that. There always can, it's an option, but many tribes simply can't afford all of the trappings of an effective criminal court system. So we need more money.
Well, I don't know that the solutions are clear, nor they certainly are not simple. But one of the premises of the so-called quasi-sovereignty theory within Indian law is that we ought to give the tribes the ability to manage their own affairs and that recognize that they have independence. And to the extent that there is oversight carried out by the state in some circumstances, by the federal government in other circumstances, I think deteriorates from the ability of the tribe. I mean, of the tribe's ability to manage its own affairs. I mean, one of the things that was brought out in the book Roundhouse is that the young man learns that his father is the tribal judge, but he has no real authority to do anything that is a serious crime. So if we could clarify the responsibility of who has jurisdiction within the tribal areas. I mean, I don't know why if you go into a tribal area, it should be different than if you go into Kansas. I mean, if you break the laws in Kansas, you are held accountable for the laws in Kansas. And I think some of the underlying challenge is I'm not sure we've got to the point where people have confidence that the tribal courts will and the tribal jurisdiction issues will function fairly to non-tribal members. I don't know how you bridge that gap, but until that perception is there, I'm not sure how you solve the problem.
Great. Okay. We have a question from Mary Ellen Sloan, who says, are there implicit bias issues when a major crime jury is impaneled when the juries will likely not be Native Americans and the defendant is Indian?
I'll take a stab at that. The answer is yes. Implicit bias is always present. And it's one of the things that as a judge, I've tried to figure out how to best deal with in terms of talking at length with prospective jurors about implicit bias. And I have no doubt that there are implicit bias issues, just as was evident in the young man that I told you about, who said, well, everybody knows that all the young Indian girls are raped or abused by their families. I don't think that's true, but I think that bias exists in the community and is difficult to overcome. And part of what I indicated before is I have a serious question if in the case that I tried, which was a very blatant case of sexual abuse over a long period of time, if the jury would have believed this young woman had we not had the DNA evidence to confirm objectively that what she was being told, what she was telling was correct.
Yeah.
And I'll just say a couple of things about this. I think that Native people are not only over victimized, we're also over incarcerated. We have very, very high rates of incarceration along with our very high rates of victimization. And in fact, most of the sex offenders in federal prisons today are Native because sexual assault is usually, a crime resolved at the state level. So when you look at our prison population and the sex offenders within the federal system, vast majority of them are Native because of the jurisdiction. In terms of these bias issues, I can recommend the work of Kevin Washburn, who is a Chickasaw and dean at the law school, University of Iowa Law School, and is now working on the Biden transition team. But he wrote several excellent articles in the early 2000s about the challenge with having impaneled white juries for Native defendants, and did some empirical looking into the issue. So it's definitely a problem for Native defendants to not have their peers, I suppose, involved in assessing the truth of the matter.
Great. Well, this is a very difficult conversation, and you've all shared sobering statistics. In terms of a last question, can you give us some hope, some bright spots? Is there anything to look forward to or to be excited about in this space, that positive developments? Can you give us any hope moving forward?
Well, I'll try. as I said, I was in Capitol Hill 1 year ago today talking to Republican senators about this issue. And, I don't think Indian law really should be a partisan issue, right? Everybody, including, one of the Republican, tenets is that small local governments work best, right? And so in trying to translate that into that language, so tribes are small local governments. They are in the best position to make decisions about their own community. And there's just this kind of stalemate happening right now. But Violence Against Women Act needs to be reauthorized, and our ask is still part of that puzzle. We kind of had to put it by the wayside during COVID, and I think it's going to pick up again here in January. So support the Violence Against Women Act, support the Feinstein version of the Violence Against Women Act, because that will address some of the non-Indian jurisdictional challenges that we face.
I would just offer one additional thought. At least in my observation, the tribes, the various tribes, have made significant improvements in terms of putting their judicial systems in order and getting training and background and providing the kind of judicial backup that should be provided. I think there was a time when judicial courts were not as well organized as they should have been, that people who participated in the judicial system on tribes' behalf were not as well educated and did not have as firm a background and basis in judicial principles. I see that is changing. I think that at least in my experience, the tribal courts have well-educated people. They are putting in place procedures that protect people's rights. And I think that as that improves, there will be additional confidence in the tribal courts that they will provide a fair and meaningful jurisprudence to people that appear before them.
Well, wonderful. Thank you both. This has been an amazing conversation, and to have two national experts on this topic come and share an hour of your time with us, we really appreciate it. I know I've learned a lot. It really has provided context to Louise Erdrich's book and why she wrote on this topic. And so, Chamagwich, a big thank you to you both, and a thank you for everyone who joined us. So just so you know, we're going to take a one month hiatus from the Dean's book review. So we're not going to have a book review in December. I hope everybody has a wonderful holiday season. But we will be back in January. We will be celebrating Martin Luther King Day by looking at a book written by John Meacham on John Lewis and his life. And so join us in January for our discussion of John Lewis and his life for Martin Luther King Day. And again, I hope everybody has a wonderful holiday season. We will see you in the new year. And Chamagwich again to our wonderful panelists. Thank you so much.